Welcome and happy Wednesday. Thank you all for joining us for an MP Wired for HR webinar. Today we're going to be covering the HR Legislative Update 2024 Summer Legislative Update. So be sure to grab your lunch, coffee, whatever it is to get you through the day because this is going to be a good one. I'm Katie Prater, Marketing Manager here at MP. For those of you joining us for a webinar for the very first time, MP combines cutting-edge user-friendly HCM software with proactive white glove customer support, recruitment process outsourcing, and HR services that keep business leaders abreast of the latest HR updates and compliance requirements. I'm thrilled to introduce your expert for today's webinar, Paul Corellis. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM certified HR professionals at MP. Together, they assist clients with compliance, training, and HR guidance and support for the full employee lifecycle. So you have the pro giving you all the details for today. First, a few housekeeping issues before we get started. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will have a Q&A section at the end where Paul will go over some of your questions. Feel free to drop questions in there. So with all of that, I am going to hand the mic over to Paul.
Great. Thank you so much. Howdy, everybody. Welcome to another edition of our semi-annual legislative update. This is one of my favorite sessions that we do in webinar format. Got a lot to get into, so I will dig in shortly. Interesting landscape, so I'm not sure what the cause is, but when we time out these webinars, we really look to aim them for a little bit before the end of the legislative session that each state has. So for instance, I'm sitting in Massachusetts at the moment, and their legislative session ends at the end of this month, July. And usually we see a lot more kind of hitting the table, hitting the respective governors' desks, getting signed into law, getting vetoed, so we have a better picture. A lot of states, and you can read about it out there, a lot of states are really behind. They're kind of clogged up with a lot of different bills, a lot of different things they're considering. So with a lot of the stuff, still in a wait and see approach to see what's going to make it out of committee, what's going to make it to a vote, what's going to make it to passage into law, most likely with an effective date of January 1st. So we will talk about some of those trends, some of those things that are getting kicked around at state houses, some stuff that has passed in recent weeks and months. The January session that we do is going to be an interesting one. A lot of that will hinge on how the presidential election goes and the Senate and House elections as well, to give us a better idea of what we can expect from the legislature in terms of what's passed at a federal level. Also, if there is a change at the White House, how that could impact the federal agencies and what they do in the courts. So a lot to get into. And as I said, we'll dig right in. So with this format, as opposed to some of the other legislative updates we've done, I'm going to do a little bit of a deeper dive because there's some really big stuff at the federal level affecting everyone essentially that we want to talk about in a little bit greater detail. So we're going to talk about the new overtime rule. Pieces of that went into effect just a little over a week ago. We're going to talk about the Federal Trade Commission's ban on non-compete agreements and what that means and where that stands as of today. We're also going to talk about, this is kind of the third one that is really just as important, but isn't getting as much media attention, the Pregnant Workers Fairness Act. So the final regulations for that just went into effect a few weeks ago, and has not, again, caught a lot of headlines, but it's really important stuff. Should you have employees in your workplace that could potentially be impacted by this, there are some really strict rules and high expectations for employers that you should really know about. We're also going to talk about a couple key Supreme Court decisions that you may or may not have heard of. Their session just ended, and there were some stuff that can potentially affect employment law that was decided upon. We're also going to talk about a few cases at the district and circuit court levels too, because those are important as well. And as promised, we'll do a state law roundup in terms of what trends we're seeing at the state level, because those can just really complicate things for employers, especially if you have multiple locations or remote workers in other states. You're a multi-state employer and you really need to stay on top of those things because you may have a different rule book or a different set of policies for employees in one location versus employees in another. So it's really, really important to stay on top of that. All right, so let's dig into the federal overtime rule. So what this all has to do about was an action by the Department of Labor. They have rulemaking authority. and work under what's known as the FLSA or the Fair Labor Standards Act. So the Fair Labor Standards Act dictates a few things at the federal level. They set the federal minimum wage, which I think since 2009 has been set at 7.25. No news about that changing anytime soon. It also, FLSA also mandates overtime pay. So when more than 40 hours in a work week are completed, anything after that is time and a half of the regular rate for non-exempt workers. They also set the record keeping requirements in terms of keeping track of non-exempt workers' time worked, as well as all the kind of pay stub requirements and all the record keeping that employers have to do to prove that they're in compliance with the Fair Labor Standards Act. And the FLSA also sets the federal youth employment rules. So we'll talk about it in a little bit. A lot of states have different youth labor and child labor rules, but at least at the federal level, the Fair Labor Standards Act dictates those. So when we talk about the Fair Labor Standards Act, and what we'll be talking about, the aspect of it we'll be talking about today, it comes down to the classification of your employees. So sometimes people will say, I've got salaried folks or hourly folks, and that can very well be the case. But when it comes to compliance and making sure you're following the FLSA and the Department of Labor and federal rules, it's really important that you have confidence in your classification of your employees as either exempt or non-exempt. So when it comes to non-exempt employees, a lot of people will commonly and sometimes mistakenly refer to those as their hourly folks. Non-exempt employees are also overtime eligible employees. They don't necessarily have to be paid hourly. You can have salary non-exempt, which we'll talk about shortly. You can be paying them by the hour, which is probably most common. You can pay a day rate, you can pay a job rate, you can pay a piece rate, something like in manufacturing, for instance, or you can pay them on a commission. Any type of compensation. They're not necessarily concerned about that for the non-exempt folks. But you do, either way, whether you're paying them hourly or some other way, you do need to be tracking the hours, because in terms of compliance, that is measured on an hourly basis. So even if you're paying them on a daily rate or a piece rate, whatever it is, you need to know the hours that were worked, because those hours need, and the pay that you're giving them for that time needs to at least meet minimum wage, either at the federal level, or if you're in a state that observes a higher minimum wage, that they're paid at least that. And should their hours worked exceed 40 in a work week, and this can get tricky with your salary non-exempt, so your piece rate folks, you need to be able to calculate the appropriate regular rate for them and pay them time and a half of that. So hours worked don't necessarily just include the hours that they're actually performing tasks for you. There are a lot of other aspects of a workday or working time that are considered hours worked under the FLSA. And these may impact some industries more than others, but things like on-call time, certain rest periods, any break that's less than 20 minutes needs to be compensated. So we've seen a lot of employers get tripped up in that in litigation over the last few years, where whether it be people stepping outside to smoke, or we've seen some employers make people punch out to go to the bathroom, which is hopefully an obvious no-no. But really any break time shorter than 20 minutes needs to be paid regardless of the reason. So it's something to be mindful of, and a key takeaway of our presentation today. Training time. Again, there's a lot to that. So for the sake of time, we won't go into great detail, but please reach out to us if you have questions on what training time needs to be compensated and which is optional in terms of compensation. Also travel time. So the rules on this can vary, at very high level. You don't necessarily have to compensate folks for the commuting time to get to their first work destination or to the office. But if they're traveling throughout their workday, you think about home health care, or people doing handyman work or construction type work that are going job site to job site. In most cases, that travel time from one work location to the other is considered compensable time. Again, in some cases, in some industries, things like sleep time are also considered hours work. So just things to be mindful of. And when it comes to a lot of these, you can set a separate rate. So if you pay someone $20 an hour, $30 an hour, whatever it may be for their working time, as long as it's disclosed ahead of time and agreed upon and you give proper notification to the employee before they actually work those hours, you can come up with separate, on-call rate, travel time rates, things like that. You do have to be mindful of minimum wage, but there are ways to get creative with it and make it a little bit more cost effective for the business. So when it comes to your exempt employees, there are really a few key aspects and a few key thresholds. So first of which, and really where the overtime rule change that the Department of Labor just passed this year, has to do with the weekly salary threshold. So um, regardless of what an employee's duties are, if their pay is less than that new weekly salary threshold, they're automatically non-exempt and eligible for overtime. So we're going to talk about that more in a second. Generally, for most of the exemptions, they need to be paid on a salary basis, so kind of a guaranteed rate for any week in which they perform any work. There are a few exceptions to that. For instance, outside sales people, there is an outside sales exemption where that doesn't have a minimum salary requirement. So you can have an outside salesperson be 100% commission with no base. And as long as they're truly an outside sales worker and meet the qualifications and job duties for that, that's fine. That's acceptable. They don't have to be paid a guaranteed salary. Similarly, computer workers have their own exemption where there can be an hourly rate for those folks. There's also a motor carrier exemption for certain truck drivers and truck mechanics and things like that that can also be paid an hourly rate. That's also exempt. But if you have those questions about that, or you have people in those positions, especially the computer workers one, that's very tricky. It's very specific. It's not anyone that happens to work on a computer for the majority of their workday. They have to be doing certain things and have certain responsibilities to qualify for that. So in addition to the salary amount and the salary basis of pay, they also, and this is where it can get really tricky, they have to meet the job duties test for one of the white collar exemptions. So these are the most common white collar. First is the executive. So those are generally people who are managing others and have significant decision-making authority over their hires and fires and disciplinary actions, things like that. Your store managers, your general managers, things like that will generally fall under the executive exemption. You then have the administrative one, which is common, but there's a lot of gray area there, and we find a lot of businesses misclassify workers who should be non-exempt as exempt under the administrative exemption. With this one, it really has to do with their decision-making authority. Do they need approval for anything, or do they have some sort of significant authority and autonomy to make decisions of significance? So again, sometimes that can be tough to decipher. We work with a lot of clients on this. It's part of our HR services. If you have questions on that, please reach out. There's also the learned professional. So that's when someone has a very specialized degree, think scientists, think CPAs, things like that, where they may not be managing others. They may not have significant decision-making authority at the company themselves, but they have a very high specialized level of expertise in their field. Again, usually that comes with an advanced degree. Those folks tend to fall into the learned professional category. You then have the creative professional, so people in the arts, in certain instances, will be correctly classified as exempt. Again, the computer professional, that has to do with very specific computer professions. The outside sales that I talked about, note that it is outside sales. So with the exception of California, which does have an inside sales exemption, that's the only state that I know of that has one. At the federal level and at most state levels, if you have folks doing inside sales, in a call center, calling out, not getting outside of their workplace, whether that be at home or at an office, and actually visiting with prospects or clients, those folks most likely need to be classified as non-exempt. And that's probably one of the most common misclassifications that we run into. And then there is the highly compensated, which we'll talk about in a minute. Basically, that means that they have a salary level that's above and beyond the minimum salary amount. That number is a moving target. We'll talk about it in a second. But when you have someone who's highly compensated at a certain level, there's less emphasis on the job duties. So as long as they kind of hit one of the job duties within one of the other exemption categories, as long as they're meeting that highly comped level, they're generally okay to be exempt. In terms of common mistakes that we see as we work with clients and businesses, in these areas. Um, Again, just assuming someone is salaried, is exempt, you just have a policy that everyone gets paid a salary. Everyone from the receptionist to the CEO, everyone is a salary, and we don't need to worry about tracking hours or paying overtime. A lot of businesses have gotten themselves into some very expensive situations thinking that way. Supervisors, so that can be really tricky. There have been several cases over the years, especially at like large retail chains, where assistant managers and supervisors have been classified as exempt, but when they really examine their job duties, they don't have enough authority or enough say in the hiring process or the firing process to really classify, or maybe they don't supervise or manage enough people to be able to meet that exemption. Job titles can be a trap. So, I always go back to the example of office manager. So it's got manager in the title. That sounds important, but you really have to look at the job duties because oftentimes you'll see office managers at every end of the spectrum. You can definitely have an exempt office manager if they're planning all the travel for everybody, entering into contracts with suppliers, things like that. That can certainly fall under the administrative exemption in certain cases. Whereas if you have an office manager that needs management approval for anything, they're really kind of serving as a glorified receptionist. It's going to be a lot harder for that office manager to be considered exempt, even though they have the same job title as someone who is. And then the highly educated. So we talked a little bit about that learned professional. And that's great. It is important to, when you fall under that one, to have that degree or that level of learning. But just because someone, even has a doctorate, if the job that they're performing on behalf of your business isn't related to that or doesn't require that level of expertise, then that doesn't mean they're exempt. So, if you've got a doctor who's flipping burgers or something like that, yeah, they have an advanced degree, but the work that they're doing is not that of an exempt professional. So in terms of enforcement, when it comes to these rules, we're seeing a growing number of Department of Labor audits, Federal Department of Labor, and state departments of labor too. Sometimes they'll target an industry. What we've seen over the last couple of years is they've gone on after a lot of businesses that tend to hire minors and really dig into the child labor aspects of state and federal labor laws. And really, they'll go in. A lot of times, they're just looking to gather the facts. A lot of times, they will interview employees as well, especially if there's been a complaint. So they'll first ask you to furnish some information, payroll records, new hire documents, things like that, and take a look at those. If they suspect something or if they received a complaint, a lot of times they will ask for contact information for some of your employees, and they will reach out to them and ask them some questions. Um, if you're cooperative, if things are generally on the up and up, and hey, everyone makes mistakes, and they certainly understand that, you provide what they're asked for. Don't necessarily need to provide things that they're not asking for. But generally, when you're cooperative, and it doesn't seem like you're being malicious or you're generally doing things right, there are definitely instances where they'll make recommendations and help you get into compliance with very little, if any, penalty. Um, when it comes to the federal rules, if they do find errors, generally they'll look back 2 years. So you shouldn't expect to get requests at a federal Department of Labor audit for anything greater than 2 or 3 years. If they do fear you're being malicious or willfully and knowingly violating the Fair Labor Standards Act, they can go an additional year back, but generally it'll be within that time frame. Speaking of lookbacks, I don't have a slide for this, and this is completely unrelated, but I do want to mention it because it is important. We are seeing a ton of notices from the IRS regarding Affordable Care Act or ACA filing pertaining to the 2021 and 2022 years right now. So if you feel you were a large employer during that time and may have missed out on filing or missed out on your ACA compliance, definitely reach out to us if we're your payroll provider or whomever you use, just to make sure you're all set with ACA, because those notices are flying in. We're talking to a lot of businesses that thought they had kind of gotten away with skipping out on that, but it's coming back now. So they're up to 2022. All right, back to what we were talking about. Sorry about that. When they do find that a company missed out or didn't properly pay their employees, they will arrange for recovery for those employees of the back wages. They will supervise that. The Secretary of Labor also reserves the right to file a lawsuit for back wages, also add in penalties and liquidated damages, either to the agency or to the affected employees. Employees also have the right to go into litigation, as I'm sure you've seen, for back pay, liquidated damages, attorney's fees, and court costs. So it can get very expensive. We've seen a lot of, and we'll talk about this in one of the court cases that we kept an eye on. If you are found guilty of this, if you do have to pay the wages, just pay them. Do not retaliate. Do not take things out on the employees. If you goofed up, you goofed up. We all make mistakes. Make it right. Do not, we've seen employers over the years create a deduction to get that money back because they didn't feel it was correct. Or, as in the court case we're going to talk about in a few minutes, trash the employee or employees in question via social media. Don't do any of that. I think it goes without saying, but if you do have to pay something, just pay it and move on and move forward compliantly. So in terms of what the penalties may be in addition to the actual lost wages, the time and a half or the minimum wage, whatever it is, if they and again, this is when an employer doesn't cooperate, or there's evidence this might be a third time they're getting in trouble for this, or the documents show that they knew what they were doing was wrong. We found, especially recently, that the government does respect a good faith effort for compliance when it comes to things like this. They're not going to unnecessarily be hard on companies trying to do the right thing and just misunderstanding the rules. They will make you pay, but as you'll see here, when they do feel you're being willful and malicious, the penalties rise quickly. So for each instance of a willful violation, they can charge you criminally. They can fine you up to $10,000 per instance. They can imprison you with a second conviction. And then repeated violations, you can get $1,000 additional for each violation. And child labor, they take very seriously. So each violation there can be $10,000. All right. So in terms of the new rule, we are here. This new rule and the final version of it kind of comes in two stages, the first of which took effect July 1st. So we are here. And it really, again, really talks about the salary level test. That was the only change they made. They did not touch the job duties. They didn't create an inside sales exemption. They didn't create new categories for the computer workers exemption or anything like that. They simply modified the salary level test. So what they did was they increased the salary levels for the exemptions. They also increased the highly compensated exemption, and they put it in two phases. So the first of which was of 10 days ago, July 1st. The second of which is scheduled to start on January 1st of next year. In addition to these one-time changes, they also set in motion an automatic indexing. So they didn't just pull these numbers out of thin air. They used it as a percentile of the average salary in the lowest paying economic region in the US, which is the southern portion of the United States, and made it a percentile of that average. So what they're going to do every 3 years, starting July of 2027, unless it gets blocked by a court, is do an adjustment based on that same percentile of the average salaries in the lowest economic region in the United States, and every 3 years following. So the next one will be in 2027. After that, July of 2030, and they'll automatically change the minimum salary in accordance with those percentages. So prior to July 1st, the minimum salary amount was $684 per week, or $35,568 annually. As of July 1st, that was bumped up to $844 per week, or $43,888. So if you're paying folks less than that right now, you are, and treating them as exempt and not eligible for overtime, you are technically out of compliance. Barring intervention by the courts or somebody else, that minimum is set to increase rather dramatically January 1st. So it's going to bump up from the 844 and 43,888 to $1,128 per week, or 58,656. So again, a pretty big jump. That highly compensated exemption that I talked about, was 107,432. As of July 1st, it is now 132,964. What that means is, if you have someone making less than that, you want to make sure that they really meet and fall into one of those exemption categories that we talked about. As of January 1st, it's going to bump up even further to $151,000 a year and change. So this is what we covered. The 35th percentile of average salary earnings in the lowest census region are what that regular exemption threshold is based off of, and they use the 85th percentile for the highly compensated employee. There was a few legal challenges to this new rule. You may recall back during the Obama administration, they were set to make a fairly dramatic increase with automatic indexing. At the very last second, less than a week before it was set to take effect, a court blocked that rule across the country, and it never came to be. There was a very similar challenge to this rule in a district court in Texas, filed by the state of Texas. They have not made their final ruling on this yet, but they did issue a temporary injunction blocking it, but only blocking it for employees of the state of Texas. So not employees who happen to work in the state of Texas, but actual government employees working for the state of Texas. Those, the state of Texas does not have to comply with the July 1st salary threshold at this time. They are still sorting out that case. There is still a chance that the January 1st and perhaps even the July 1st increases are rescinded and taken down. But as of right now, it's full steam ahead. The July 1st rule is the law of the land. And as of right now, the January 1st change is on pace as well. So really the best thing you can do is prepare. It could get shot down. It could go into effect. There were a lot of employers who just assumed that the July 1st increase wasn't going to happen and kind of got caught a little bit flat-footed when it did go through. So great time to identify all of your exempt employees, all your salary levels, identify anyone who's falling below those, especially if it's a July 1st person, you got a decision to make immediately. And, depending on how far away they are from those, you may want to bump them up, or you may need to make them non-exempt. Communication, as with any change, is key. It's really important you communicate effectively. We have templates. We can create custom things for our clients. If you're interested or in need of that, please let us know. I always find that, sometimes we work with businesses who find that even under the new rules, they probably had someone who should have been non-exempt. This is a great time on the heels of a big federal regulatory change to say, hey, we've studied this in light of the new laws, and to be compliant going forward, we are changing you from exempt to non-exempt. You don't have to go so far as to say you've been non-exempt this whole time and we weren't doing it correctly, but it's going to raise fewer eyebrows if you do it during this big change, during a change to the federal laws, rather than kind of doing it out of the blue. All right, so for the sake of time, I've got a lot to cover. I'm going to, I'll just say it's really important your managers and supervisors are properly trained, that they're not doing things that run afoul of the FLSA, having people work off the clock, making people punch out for under 20-minute breaks, things like that. We do offer full manager and supervisor training if you're in need. All right, let's talk about non-compete agreements. So this is another one where a government agency made a rule. In this instance, it was the Federal Trade Commission, who we don't necessarily get a lot of employment law related rules from, but in April 23rd of this year, they issued a final rule that said they were essentially going to ban nearly all non-compete agreements across the country. So this not only would eliminate new hires from receiving non-compete agreements, it would also eliminate retroactively existing non-competes as well in most cases. This is set to take effect September 4th of this year. Again, as I said, all existing non-competes would be unenforceable once it's effective. There is a tiny exemption for senior executives that earn more than $151,164 are in key policy-making positions. So you may even have folks who are VPs that make that amount of money, but they have to have really significant decision-making authority at the company for their non-compete to be valid. Really think kind of C-suite and above to be safe. After the rule takes effect, should it take effect in September, even those senior executives that we just talked about, if they're newly hired or there's a new non-compete being introduced to them, you can't do that. That exemption is only for existing non-competes. So I'm going to skip to the important stuff for the sake of time. Should this go into effect, you are going to be required by law to provide a written notification to anyone who does have an existing non-compete in place to let them know that it's no longer enforceable. The Federal Trade Commission does have a sample notice, and they're being pretty lenient in terms of how that's delivered. It can be done physically, you can mail it, you can email it. You can no longer have a non-compete agreement. This does go back as well. In terms of confidentiality and non-solicit clauses, oops, those are still okay as long as the language within them can't be considered a non-compete agreement. So still okay to have those. You just want to be careful, maybe have an attorney review those to make sure that they are still compliant in light of this new rule. Again, should it take effect. So similar to the overtime law, we are seeing some legal challenges with this as well. And just a week ago today, July 3rd, a court did rule in one of these cases, gave the plaintiffs in that case a preliminary injunction that as of right now, they don't need to worry about the non-compete rule. And, we don't want to jump to conclusions, but based on what they said in that decision, it's likely that they'll probably shut this down for everybody. So I wouldn't go overboard in terms of worrying about this. Again, I would definitely plan for it, be prepared should it roll on. They have promised a formal decision in that court on or before August 30th. So, 5 days or so before it's set to take effect. So we will have some clarity at that point, and we'll certainly send something out to everyone on our mailing list in terms of what that court decides, whether it's yay or nay. But in terms of legal experts that I've spoken with and their interpretation of the tea leaves that have kind of came about through this case, they're saying that there's a fairly good shot that they'll shoot this down, but they haven't done so yet. So as with the other, we need to be prepared for it to move forward. So in terms of what you can do to prepare, take inventory of what non-competes you have within your workforce. Do have notices on standby for September should you need to send those out to those people. Take a look at your non-disclosure agreements, make sure they're not overly chilling or mention non-competition. Consider maybe having, if you don't already have a non-disclosure or non-solicitation agreement, to have people enter into should you not be allowed to enforce their existing non-compete. And again, consider legal counsel for some of this stuff just to make sure that all of your language is on the up and up. All right. Next, I want to delve into the PWFA, or the Pregnant Workers Fairness Act. So again, this hasn't gotten quite as many headlines as the other two, but is really equally important. So this was a rare instance of bipartisan Senate and legislature support for a law. It passed a while ago, but it took them a while to come up with the formal regulations here. But what it was addressing was kind of some holes within the ADA, or the Americans with Disabilities Act. So the Americans with Disabilities Act covered pregnant workers when they had a disability that otherwise fell under the ADA, but pregnancy in and of itself was not protected. So what the PWFA does is requires employers to provide reasonable accommodations to folks at various stages of pregnancy and things leading up to that and things following pregnancy. So it technically went into effect over a year ago, June 27th of 2023. But the Equal Employment Opportunity Commission, who was tasked with kind of enforcing and setting the rules for this, took some time to create the regulations. It's dozens and dozens of pages. It's a big one. And those went into effect a little less than a month ago, June 18th. So what you need to do as an employer, things you must not do, rather, you can't not reasonably accommodate known limitations of an employee unless there would truly be an undue hardship to your business to do that. You can't make them accept an accommodation that you've come up with without going through that interactive process, which you may be familiar with from the Americans with Disabilities Act. And you cannot deny a job, deny a promotion to an otherwise qualified employee because they need a reasonable accommodation because of their pregnancy, pre-pregnancy, or post-pregnancy condition. In addition, you can't force an employee to take leave if you can accommodate them in some way that doesn't cause a hardship to you. Definitely can't punish, can't retaliate because of someone exercising their rights under the PWFA, or if there needed to be an investigation, anyone who participated in that. And you also can't coerce folks who are utilizing their rights, try to talk them into taking a leave or doing the accommodation that you feel is best. You got to be careful there as well. So as you can imagine, if those of you who have been in business for quite some time, a lot of accommodations can be very industry or job specific. So there's a countless number of potential reasonable accommodations, but within the regulations, they did draw out some that are going to presumably be reasonable, that you shouldn't really necessarily need medical documentation for, or you shouldn't have to go into some deep interactive process to determine and grant. So these things include allowing an employee to carry or keep water nearby, have those drink breaks as needed, allowing an employee to take frequent or additional restroom breaks as often as they need. If an employee is required to stand but can still perform their job sitting, that they can either sit while they perform their job or have a chair nearby to sit when they need to, and allowing an employee covered by the PWFA to take breaks to eat or drink as needed. So these things you really shouldn't push for. You shouldn't say, hey, I need a doctor's note to let you do this that says you need to be able to drink or need to be able to sit. You should be pretty easygoing when it comes to things like that. Some other potential reasonable accommodations that may or may not need a doctor certification or recommendation: longer breaks, more flexible breaks, changing your policies in the workplace, obtaining new or changing equipment or workstations that make the job more doable for someone who's having issues, dress code changes or relaxation, perhaps alternate schedules, changing someone's hours or when their work time is, allowing for telework in some cases, temporary reassignment to a new role or a new location. We'll talk about this a little bit more in depth, but temporarily suspending an essential function of a job. So if you're familiar with the ADA, you know that this is not part of the ADA, that when you are being compliant with the Americans with Disabilities Act, you're creating reasonable accommodations that are going to allow them to perform the essential functions of their job. If there cannot be a reasonable accommodation made for that person, then you don't necessarily need to accommodate them. I think of the instance of a limousine driver or a bus driver who, goes blind. There's no reasonable accommodation that can be made for them to continue to do their job. You're kind of off the hook to comply or to accommodate them. Things change a little bit different under the PWFA. We're going to talk about that in a second. And this is it here in a nutshell. So under the PWFA and the regulations released by the EEOC, they are also qualified and may need to be accommodated if their inability to perform an essential function of their job is temporarily prohibited. But they will be able to provide it sometime in the near future. And what they mean by that is if you have a worker covered under the PWFA pre-pregnancy, pregnancy, or post-pregnancy who can't perform one of their essential functions of their job for up to a time frame of 40 weeks, but presumably will be able to do it after that time, you still may need to be required to accommodate that employee. So this is a big departure from the ADA, and it's something really important that employers understand that this changes the game a little bit. Uh, They also made it clear in the regulations that employees don't need to formally request accommodation under the Pregnant Workers Fairness Act, that they're expecting employers, and this includes managers and supervisors, to recognize these requests, even if they're not formal. So if you have an employee say, hey, I'm pregnant, I need more bathroom breaks, I'm suffering from morning sickness, and I need to change my working hours a little bit if possible. These are all instances where you need to enter into the interactive process with the employee. Okay. In terms of reasonable accommodations, if there is something that's going to cause an undue hardship, and that bar can vary depending on the size of the company, the budget of the company, things like that, in terms of what is going to cause an undue hardship, that can be different from one employer to the next. But I would just advise the bar is fairly high, so you really have to prove that it's going to be detrimental to your business to not accommodate the worker. As I said before, there are certain instances where asking for a doctor's note or certification is appropriate, but the EEOC really stressed common sense in their approach to these regulations, that, and practicality. It's hard to get a doctor's appointment a lot of times nowadays. So if someone's suffering from morning sickness, are you really going to require them to find, time to get an appointment with their OB, or are you just going to kind of accept them, at their word? To exercise some common sense with this. And one really important thing to keep in mind here is that the PWFA, or at least as it currently stands, there are legal challenges to this like there are with the other two. This covers a wide range of timelines within the pre and pregnancy and post-pregnancy timeframe. So some folks who are covered currently by the PWFA include folks who are going through fertility issues. So those folks are covered even if they may not be pregnant as of yet. This also covers things like abortion, and that's really where the legal challenge is. There's a court case right now in a district court, I believe in Louisiana, who's challenging the legitimacy of the PWFA because it does cover folks needing accommodations either during, pre, or post abortion. So we'll see how that shakes out. That is still in the courts as we speak. Um, Obviously covers people during pregnancy, during childbirth, and also covers folks postpartum. So, if they need nursing accommodations or to pump milk and things like that, or other things that can happen postpartum to folks, an employer would be expected to accommodate that as well under the PWFA. Short of working with an HR professional, the federal government does have a great website called the Job Accommodation Network, or JAN, and that can really help sometimes with tricky accommodation requests. All right. So speaking of the EEOC, let's kind of talk about what's on their plate right now. So they recently released their focus and points of emphasis for the next couple of years. And they've made it very clear they are going to really seek to help out what they consider vulnerable and underserved workers, and make sure they're aware of their rights and have the ability to seek help should they be discriminated against. So in terms of folks that they've identified, that they, communities, low socioeconomic working communities, things like that, people who may have difficulty with literacy, people who may have barriers to getting access to computers and online resources. They're really working on campaigns to get in front of those people, make them aware of their civil rights and their other EEOC rights, and making sure that they're doing their part there. One of their other major focuses is artificial intelligence, other technologies that may have biases. So they're really working hard to set some guidelines and expectations for businesses and technology companies to make sure that the software that they're using, and sometimes making significant employment and housing and other type decisions on, is not going to be biased or discriminatory. Coming off of Pride Month last month, they are also doing a lot of campaigns protecting the rights of employees based on their gender identity, and sexual orientation. So that's another big focus point of them right now. There were several lawsuits against businesses and charges filed against businesses for discriminating against folks. A lot of times you're seeing, you know, employers discriminating or making fun of or singling out people based on how they present and things like that. So you got to be very careful with that. They're also looking to eliminate barriers, specifically in recruitment and hiring, to make sure that there's a level playing field for folks when they're applying for jobs. A ton about equal pay on all of the protected classes that are protected at the federal level. And they're also doing a campaign and a focus on systematic harassment, especially sexual harassment. So looking for businesses who just have a track record. It's not just a one-off where one employee has been picked on, but certain groups are being harassed, either sexually harassed or other discriminatory reasons harassed based on their race or gender or whatever it may be, that they're nipping that in the bud. So the EOC and the Civil Rights Act of 1964 is celebrating its 60th anniversary. That was just a couple weeks ago. So they're full-fledged and really look like they're going to have an aggressive campaign over the next year or two. On to the courts. There have been some really important court decisions over the last few weeks, really. The one that we're talking about the most and really seeking some clarity on is the overturning of what's known as the Chevron deference. So much like the Roe versus Wade, Chevron isn't the current case that was decided. There were actually 3 and somewhat 4 cases that were heard and decided upon that overturned Chevron, which had been in place for 40 years, since 1984. So much like we, at least I don't know what the case was that changed Roe versus Wade. There were a few cases there that didn't actually happen to do with employment law, had to do with some fisheries and some other things like that. But what this did will definitely affect employment law, or at least has the chance to. So you may have heard this term or this case in recent weeks, but really what it had to do was federal agencies and the power that they have, and when the courts need to defer to federal agencies when it comes to their rulemaking process. So aside from the Pregnant Workers Fairness Act, which was a piece of legislation passed by the House and Senate and signed into law by the president, the other 2 rules we talked about, the non-compete ban, the overtime rule, a lot of other rules that we talk about in employment law and significant things, come from the federal rulemaking process by federal agencies. So until this was overturned, what the Chevron case really dictated was that when a rule was considered reasonable, when there are ambiguities or things in question that were presented to the court was instructed to defer back to the agencies for interpretation of things that weren't clear or ambiguous. So it gave more power to those agencies to really set the rules and enforce the rules. What happens now is it gives the power to the courts to interpret things that are ambiguous, and based on their interpretation of it or their knowledge of the Constitution or other relevant laws, gives them the power to say whether aspects, or in some instances, the entire federal agency rule is legal or not. So with all those things we just talked about, the non-compete, the overtime rule, even the aspects of the Pregnant Workers Fairness Act that that court in Louisiana is deciding upon, it gives more power to the courts to make some changes to those. So what this means for employers is you really need to be tuned in, or be working with someone like us who is, because now more than ever, we've always cautioned against practicing HR via Google. This is going to become all the more important now, because simply knowing what the rules are and what the laws are is not going to keep you compliant. You need to be keeping up to date on these significant court rulings, not just at the Supreme Court level, but at the circuit courts and the district courts and whatever they may be, because these could completely flip the rules on their head. And to further add to the complexity, if you're a multi-state employer, this is going to create a special complexity for you, because it's one thing if the Supreme Court rules on something, that becomes the law of the land in all 50 states. But if a district court rules on something, or a circuit court, they only have governance over sometimes a handful of states. So you could find yourself in a situation where, let's say it's that overtime rule. They rule that certain aspects of that are going to be changed, but they only have the authority to change it in those handful of states. So let's say you have offices in New England, and you have offices, in Texas. Your employees in Texas may all of a sudden be subject to different rules than your employees in New Hampshire, Vermont, Maine, wherever it may be. So you really need to stay on your toes. You need to make sure you're working with, either your internal HR department or HR advisories and legal counsel that is staying on top of these things and knowing how best practices are changing, even when the rules or laws themselves aren't changing. So really important to stay on top of this. It's going to create some complexities for sure. In terms of some of these other cases, I know we're running up on time here. One important one is this Mobley versus Workday case. So this is a case where an employer was using an AI software in their recruiting practice that was found to have some biases in it. And what this really does is talk about liability of an employer when they're working with a third-party vendor who may be, knowingly or not, and especially with technology, utilizing a software that may not be compliant. So it's really important, if you are working with third-party vendors, especially with AI type things, don't be afraid to ask them, have they conducted bias testing? What are their obligations, and what is their commitment to avoiding discriminatory actions within their software? Because there is some shared responsibility there. So you want to make sure any vendors you're working with, especially technology vendors, are being mindful of that and being compliant, especially with discrimination and bias concerns. Another important one is that Sue versus Bevins and Son. That's one where an agency found that the company had violated some of the labor laws and wage and hour rules for an employee, and had to pay them some back wages. The employer then went on to bash the employee on social media and encouraged the public to look at their criminal record and so on and so forth. And it just got really ugly, and they're going to have to pay a lot more money now because they decided to retaliate against that worker. So be careful there. I did also want to quickly cover some state law trends, what we're seeing out there. We're now up to 11 states and Washington, D.C., who do have pay transparency laws passed. What this usually means is having to include salary ranges on your job postings out there. So if you're hiring, and especially if you're hiring remote workers or work that might be performed in one of those 11 states, make sure that you're following the pay transparency rules there. We're also seeing many states adopt different types of paid leave, whether it be Illinois with kind of their 40 hours of paid sick or paid time to use however you want, that recently went into effect, or paid family medical leave laws that are gaining traction in several states. One of the newest trends we're seeing is leave for pregnancy loss. So, in the unfortunate event that an employee loses a baby due to miscarriage or something along those lines, that there is a job protected and or paid leave for that. California was the most recent state to pass that. That is going into effect there, but several other states have that tossing around their legislature as well. We're also seeing restrictions and limitations on background checks. I think the most noteworthy of that is in Massachusetts, who we're not sure if this is going to pass before the end of the month and before the end of the legislative session, but they did pass it in the House of Representatives, a bill that would essentially ban credit checks from being used in employment decisions. So if you do credit checks as part of your hiring process, should that go into effect and be signed by the governor, you'd no longer be able to use credit checks as part of your background screening process. Also, states are jumping on the AI bandwagon, creating data protection laws and other restrictions on AI companies to protect personally sensitive information, and also, again, get ahead of discrimination and bias concerns with AI. With the uncertainty of that federal non-compete ban, a lot of states are talking about non-compete agreement bans Some states already have them, have had them on the books for years. Other states are talking about it. Some of them are waiting to see how this federal rule plays out. Rhode Island, for instance, vetoed an all-around non-compete ban, but they did, I think just last week, sign in a non-compete ban on nurses. So if you're in Rhode Island and you have nurses on staff, you are no longer allowed to have them enter into non-compete agreements. And a little bit of change of direction when it comes to youth employment and work permits. We're seeing a lot of states, especially in the South, pass laws that allow for more leniency with youth workers, sometimes getting rid of the work permit requirements and things like that. Alabama is the latest to jump on that bandwagon. So they're potentially eliminating their work permit requirement for certain workers and loosening some of the job restrictions on 16 and 17-year-olds. And then last, a lot of states, I think most recently Vermont, have passed laws that ban captive audience meetings. And again, you need to check state by state in terms of the specific language for those, but generally what they are when a company has a mandatory meeting that employees are required to attend, and the subject matter in that meeting includes things of a religious nature or things of a political nature. A lot of times they're used, for union busting and things like that. But you want to be mindful if you are in a state that has banned captive audience meetings that you're careful with the agenda for any company mandatory meetings that you hold. All right, so I did want to take a second and leave a few minutes for Q&A. We will be sending out a copy of the slides and recording for anyone, because I know we blew through some of that for the sake of time. All right, so let's dig in here. At what point do bathroom breaks become excessive since they are paid? So that can definitely be a slippery slope. But if you are finding that an employee is excessively taking restroom breaks, again, if you are aware that they're pregnant, you want to give that one a little bit more grace. If they're not, you want to maybe just have a conversation with the employee. Again, if you make the assumption that they have a disability, then whether or not they do, they are then covered by the ADA. So if it's perceived, the ADA covers folks who are disabled as well as people who the employer perceives to be disabled. So you want to approach that carefully. But if you do have concerns or want to get into that interactive process, you could potentially have that conversation with the employee. And I'm not a lawyer. I'm not providing legal advice, but there are certain situations where you may be able to get medical documentation kind of permitting them to do that. If you suspect tomfoolery or something, if you're suspect of something, there are certain limited situations where you can request medical documentation to substantiate that need. Let's see. Travel time for external training. What we can do, in addition, we're going to send over the slides and the recording of this. There is a very specific checklist for training time when it is allowed to have that be not paid. And you have to kind of hit all those bullets in terms of work-related, voluntary or optional versus mandatory. I don't want to misquote anything of it. I will gather up that checklist for when you can have non-paid travel time and non-paid training time. I will get that out to everybody. The general rule for travel time is when it falls under the hours that an employee normally works. And it's important to note, not the day. So when we talk about a Sunday, if this is generally a 9 to 5 employee and you're, say, having them fly out on an 11 a.m. flight, that travel time needs to be compensated because the hours fall between their typical working hours, even though it's not a typical working day for them. So that's an important rule of thumb when it comes to travel time. California has stricter travel time rules, but from a federal purpose, if it falls between their normal working hours, again, not days, then it generally has to be paid travel time. How does benefit time work with exempt staff? For instance, if they don't have enough benefit time to cover their missed time, do we still have to pay them? So there's a very small and strict list in terms of when you're able to deduct from an exempt employee's pay. Generally speaking, if they've used their vacation time and they're not missing a full week of work, in most cases, and again, there are certain caveats, and I want to be careful from issuing a broad statement here. There are instances where you can reduce an exempt worker's salary, but it's limited. In most cases, you do have to pay them their full salary, but you can treat it as a disciplinary action. So if they've exhausted their vacation and they continue to miss time, they can face disciplinary consequences for that. And then finally, a lot of great questions here. We'll try to answer these in our follow-up. I want to give everyone a good time, and I know we're at the hour here, but just quickly, in terms of common gray area examples of the administrative classification, what we often find are employers feel that whatever autonomy they give to an employee is sufficient. That, if they're ordering pencils from Staples and things like that, that they have some decision-making authority, or they get to dictate when they go on their lunch break. It's really the matters of significance that the bar is somewhat high for the decision-making authority that an employee needs to have to fall under the administrative exemption. If it's something minor, if it's running the schedule of the conference room and who gets to use it, that's not a matter of significance. It has to be something meaningful to the company that they're given the autonomy to make a decision on. So I'd say those are the most common examples. So again, I apologize. It looks like we might have had some audio issues at some point in the presentation. Hopefully those were corrected quickly. I will write up some answers to these questions. There's some really good ones. I appreciate that. I apologize for going over. We will get those answers along with a slide deck to you all. Again, thank you so much for your time today. I'll hand things back over to Katie to wrap us up.
Thanks, Paul, and thank you all for spending your afternoon with us. To learn more about NPHR services or to get more answers to your questions, please reach out to us at np-hr.com and we can have a quick call and answer all of your questions for you. Be sure to join us for our upcoming webinar next month on pay transparency, legal insights, proven strategies, and compliance updates. You can visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out the recording of today's webinar along with the presentation slides this afternoon. Thank you all for joining us and have a terrific day.